Good morning. Good morning, everyone. Rob Bonta, California Attorney General. Thank you for joining today. I'm here to formally announce that the California Department of Justice, led by our Civil Rights Enforcement Section, has launched an independent investigation into the emergency response to the Eaton Fire and the disproportionately devastating impact it had on the historically Black neighborhood of West Altadena. As many remember all too well, the Eaton Fire burned more than 14,000 acres in January 2025. At least 19 people were killed, including 18 who were residents of West Altadena. So all but one who died tragically were residents of West Altadena. More than 9,000 buildings were destroyed, and nearly 6 in 10 Black-owned homes were damaged. It was one of the most destructive and deadliest fires in the history of California. First and foremost, my heart and deepest condolences go out to all who lost loved ones, who lost homes or businesses during the fire. The grief, the trauma they've experienced is unimaginable, unfathomable, and no amount of rebuilding can return all that they've lost. I also want to commend the community members of West Altadena who've spoken up in the wake of an unbelievably devastating experience, who've turned their pain into purpose. It's not an easy thing to do, and I have deep respect and appreciation for your resilience, your strength, and your courage. The investigation we've launched is driven by one overarching question. Did the Los Angeles County Fire Department's delay in notifying and evacuating the historically Black West Altadena community during the Eaton Fire violate state anti-discrimination and disability rights laws? Meaning, did unlawful race, disability, or age-based discrimination in the emergency response result in a delayed evacuation notification that disproportionately impacted West Altadena residents? That's the question. We don't know the answer. We don't know what this investigation will turn up, which is the whole point: to pursue the facts, uncover, reveal the facts, and to follow the facts. We're also not starting from a blank slate here. There are concerning circumstances surrounding the Eaton Fire that have raised questions, making this investigation necessary. The biggest of which is that there was indisputably a delayed emergency notification and evacuation of West Altadena. We're here to ask why. While there are other ongoing investigations into the fire, ours stands apart in that it will answer legal questions that fall under DOJ's purview, including if there was disparate impact based on race. Questions best investigated and answered by our office. While our investigation will likely incorporate information revealed in the other investigations, each are unique in scope and necessary to discover the truth of what happened 1 year ago. It's my hope and my expectation that all public institutions and officials we reach out to over the course of our investigation will voluntarily comply and share the information that we seek. We also intend to include input and firsthand accounts from the community. Good government is built on transparency and accountability, on trust. We should never be afraid to ask hard questions, to look behind the curtain at process and systems that we often take for granted, to understand what really took place, to evaluate if the processes and systems are failing certain communities, to make sure no rights were violated, no laws broken, and to take action if they were. The public, the families forever changed because of the Eaton Fire, deserve nothing less than our full commitment to finding and sharing the truth. They deserve to trust the public institutions that are here to serve them, trust that we'll show up, ask questions without prejudgment, and find answers based on facts and based on evidence. That's what we aim to do with this investigation. Finally, I want to again thank the members of DOJ's Civil Rights Enforcement Section, my CRESS team, for leading this investigation. I know they'll do so with the diligence, the thoroughness, and the commitment to transparency and to objectivity that those impacted deserve. I also want to say thank you to all of my partners in public office who have been fighting for this community since the devastating fires, helping the community on the long road to healing and recovery. And I want to say a special shout out to California State Senator Sasha Renee Perez, who I have been in contact with multiple times over the last weeks and months about this very issue. I know how deeply she cares about the community of Altadena generally, West Altadena specifically, and I appreciate her leadership, her friendship, and her partnership. Before I turn it over to questions, please note that now that this is an active investigation, there's no further information about the process and next steps that I can share at this time. But I am happy to answer any questions that you might have. Thank you for joining today. With that, I'll open it up to questions.
If you'd like to ask a question, you may do so by hitting the raise hand icon at the bottom of the screen. You can also submit questions through the Q&A feature also at the bottom of the screen. Please state your publication when I call on you. The first person is Grace. Grace, you are now unmuted.
Hi, Grace Tui with the Los Angeles Times. I wanted to better understand, why is this investigation coming now? A lot of this has been reported and in the public knowledge, especially with the delayed evacuations for more than a year. Can you talk about why now, and then also how the delay might impact either the investigation or the findings, whether it comes to interviews, things like that? Thank you.
Sure. And let me just first acknowledge and just state that I understand that there may be frustration felt by many, especially those in the Altadena community who have been searching for answers and deserve answers, and may be frustrated that it took some time to get to where we are today. So I want to acknowledge that frustration. I know that that with grief comes appropriate concern. And when someone is suffering tremendous loss, as a community, as a family, as an individual, it can be difficult when answers to questions aren't provided. So I wanted to say I understand. And I also want to underscore that just because we are announcing today doesn't mean we're starting today, working from scratch. We have done significant work to get to this point, where we thought an announcement was appropriate today. So while today is an announcement of an investigation, it's not a beginning of the work on this issue. My team has been working on it for months, and we've had multiple conversations with impacted families, survivors. I specifically had a personal, powerful interaction with impacted survivors, and that had a major impact on me. And it was important that I had that conversation. And for me as an elected public official, being able to hear directly from those who are suffering loss, pain, and hearing in their own words what happened, what they're feeling, what they're experiencing, and knowing that I can do something about it, given my official role that I have the honor and privilege of having, has always in my public service career had the most impact on me. So I understand the frustration. We're not starting from scratch, and we will move thoroughly, comprehensively, expeditiously to get answers.
Thank you. Next question comes from Laura. You are now unmuted.
Hi, Attorney General Bonta, Laura Fitzgerald with CAP Radio. Thank you very much for taking the time. This is extremely helpful. I actually have a question for you about the online portal that you launched in December for citizens to be able to report excessive force or other misconduct by ICE agents. Are you able to give an update on how many complaints your office has received since it was launched and where those stand?
Thank you for the question. And I realize there was a second part of the prior question I just want to touch on about the impact that the timing of our investigation will have on our investigation. I think that it won't have an impact. I think with the fire just over a year ago, with the work that we've already done with information evidence that's already been preserved as continues to be available, we'll be able to do the full, thorough, comprehensive investigation that's necessary here. So my apologies for not answering that in my prior response. With respect to the portal, I think you're talking about oag.ca.gov/report misconduct. We announced that to the people of California. As you mentioned a few weeks back, our hope and intent was to get input and participation from members of our broad, robust California community should they see conduct by federal officials, agents that they might believe is unlawful, and whether it be National Guards people or members of the Marines, potentially violating the Posse Comitatus Act by engaging in civilian law enforcement, which is against the law, or potentially federal immigration enforcement agents who are engaged in activities that violate the civil rights. For example, the Fourth Amendment of Californians, the Fourth Amendment rights of Californians by engaging in unlawful searches or seizures or direct detentions or stops, or maybe even being in violation of state criminal laws. Our hope and intent was to have the participation of Californians who are eyes and ears on the ground, potentially victims themselves or witnesses to this type of misconduct, and to have it sent to us so that we can review what we receive and make assessments around legality or potential illegality. And so we've had the portal open. I will say we don't comment on pending or potential investigations. I will also say that our portal is well utilized. I don't have any aggregate data to provide to you at this moment. And the portal is a investigative portal, meaning we're seeking information that could lead to potential investigation. So because it's has information that could lead to investigations, it's sensitive. And we typically don't provide a lot of additional comment on that type of information, but we do want to know it exists so that people know it's there should they decide that they want to use it to provide information to us, and it has been used.
Thank you.
Thank you.
Next question comes from Maya. You are now unmuted.
Hi there, it's Maya Spoto from Bloomberg Law. I wanted to ask you about the legal theory underpinning the investigation. I understand you all are pursuing a disparate impact theory. That's also one that the Trump administration has directed the U.S. Justice Department to stop using to enforce civil rights laws. Could you speak for a minute about the significance of that theory?
Sure. I mean, it's a well-established, long-standing anti-discrimination theory. And regardless of what the Trump administration says or does about the law, the final say of what the law is the law, not Trump's gloss or his misinterpretation of it or his politicized interpretation of it. If a disparate impact claim is available to an individual or to in our case, a public entity, then it's available. And the president cannot unilaterally take it away. And so it's unfortunate that a key legal tool that is a core and fundamental component of the anti-discrimination law that's been created in the United States of America to tackle discrimination, whether it be based on race or on other factors, that this administration is removing that from the tools in the toolbox to tackle and address discrimination. It's sort of par for the course for them. It's the most anti-civil rights department in the history of the United States at the US DOJ. They're not protecting people's civil rights. And sometimes they're actively attacking and assaulting and undermining people's civil rights. So there's no surprise that this federal administration is playing politics and taking absurd positions about what the law provides for. But our sweet spot, what we do is the facts in the law. The law states that disparate impact theories are available under certain circumstances. And when they are a perfectly appropriate tool to be pursued given the law and when the facts present themselves. So disparate impact is to be understood in comparison to um, intentional discrimination. So when there's a specific intent to discriminate in someone's head, that's one way you can prove discrimination. Another way to prove discrimination is when there is a disparate impact on a community based on a certain factor that is protected under the law, race being one of them, age being another, disability being another. And those are the three areas that we're looking at here. So I'm well aware of the position of the federal government on the issue of disparate impact claims. We are well aware of what the law provides for under state law. This is a state law claim, or excuse me, a state law-based investigation based on state law being brought by a state law enforcement agency. So whatever Trump's position is on disparate impact does not impact our investigation here.
Thank you. Next question comes from Jill. You are now unmuted.
Hi, Attorney General Bonta. Thanks so much. I am wondering if you can talk a little bit about this investigation in the context of wildfires more generally. Has your office, to your knowledge, ever, sort of undertaken a similar civil rights investigation into the response to any other of the major wildfires in the state? And then relatedly, and I know you can't talk about the process for the investigation, but can you talk at all about possible outcomes of the investigation? Are we thinking, is it possible that there could be criminal charges? Is it possible that there could be civil penalties? I know that there's a pretty broad universe of outcomes, but hoping you can talk a little bit about that.
Sure. Broadly speaking, we are in a very new world where we are seeing wildfires and incidents of fire that we've never seen before, where each one seems to be unprecedented. And the next one, all data and evidence suggests, and weren't true, but we have to look at the data and the evidence shows that the next one will be unprecedented. And so when you have unprecedented challenges, natural disasters, wildfires, you need to respond in unprecedented ways. The way things have always been done won't necessarily be the appropriate response. We need to be flexible. We need to be nimble. We need to rise to the occasion, meet the moment as it changes. And so, face the problem to fix the problem. And so we're seeing things we've never seen before. And that, and I want to say that there's a number of different reviews, reports, investigations, some of which are pending here in California with respect to the Altadena fire, and also the Palisades fire at the county level, at the state level. We've seen some final reports. We're awaiting other reports. I think those are all for the good, to look, to review, to evaluate, to assess, to recommend action, prospective action going forward so that we can be better tomorrow than we are today and improve in our responses. And as is always the goal, to be quick, to be safe, to protect health, to protect property, to protect, of course, lives, most importantly. So all that's to say we're in an unprecedented world, and we have to acknowledge that, we have to face it, and we have to respond to it. And this is, to my knowledge, the first of its kind investigation with respect to a fire response and civil rights laws as it applies to that response here in California. I have not been involved in one as AG, and I'm not aware of one prior to me in the California Department of Justice. And frankly, not sure how many there have been around the country. But the laws apply to multiple sets of facts, and the laws apply here to this set of facts. And that's why we're looking to see, to do a full vetting, uncovering, surfacing of all the relevant facts and material facts here, and see how these anti-discrimination laws apply. And of course, as I mentioned, we're not just doing it because we thought it was um, an interesting thing to do. There are some disturbing facts that we know about that suggest, and more than suggest, indicate that such an investigation is an appropriate thing to be doing to look further. But I do want to say that we're seeing a lot of things we've never seen before. And when it comes to wildfires, each one seems to be unprecedented in its own ways. And so responses like this investigation may also be unprecedented, and that would be completely appropriate.
Next question comes from Denise. Reminder just to state your publication. Denise, you are now unmuted.
Hi, Denise Poon, Fox News.
Hi.
Hello, Attorney General Bonta. Last week, you announced 7 arrests for hospice fraud. Given the growing concerns about fraudulent billing practices within California's hospice care industry, what specific steps is the California Department of Health and your office taking to identify, investigate, and curb waste and abuse and fraud in hospice billing? And additionally, how are you coordinating with state and federal agencies to ensure that vulnerable patients receive legitimate care and that taxpayer funds are properly protected?
Thanks for your question. We have long, at the California DOJ, tackled fraud. I provided um, a set of key facts in this regard at a press conference last week, I believe it was, maybe the week before, talking about the billions of dollars in fraud that we have protected, and based on our investigations, based on our diligence, based on the safeguards that we have in place, and the pursuit of transparency and accountability that we've been involved in for years. I think we provided data around for the last decade, and the billions of dollars that we've protected. So this is an issue that we have been tackling for years and continue to tackle. And it is about rooting out fraud. Taxpayer dollars are supposed to be used for the taxpayer purpose, for the service, for the program that they're designated for. And unfortunately, there are bad actors who try to improperly enjoy ill-gotten gains where they see billions of dollars flow, like in the very large state of California, where we have robust government services and provide those services to people in need, people who are hungry, people who are unhoused, people who are sick. And so we focus on the bad actors, try to successfully identify who they are, holding them accountable, and protecting those dollars. And we've done that for years in many different spaces and places, corporate fraud, healthcare fraud more broadly, and yes, including hospice fraud. And I did a press conference on specifically all of the important work we've been doing on hospice fraud. One of the important approaches that law enforcement entities and agencies like mine need to pursue is identifying trends and spikes and in different unlawful conduct. And hospice fraud, unfortunately, has been one. And we have taken multiple actions in partnership with the federal government. I might add, at times, we have a whole team that teams up with the federal government, works together to root out fraud broadly in the healthcare system when it comes to improper, fraudulent taking of Medicaid and Medicare dollars. And we've focused on hospice care very recently because that's been a trend in fraud that we've seen. And we made an announcement last week. We've made multiple announcements in the weeks, months, and years prior to that around fraud that we've tackled in the hospice space. And I don't think we're done making announcements with respect to the fraud that we're tackling. But the point is, we tackle fraud. We've done it for years. It's part of our bread and butter. We do it well. We've saved billions of dollars. We've saved it broadly in the healthcare space, more broadly than that in other spaces as well, including corporate fraud more generally. And very specifically, we have tackled for years successfully hospice fraud, and will continue.
Thank you. Next question comes from Jacob. You are now unmuted.
Hi, this is Jacob with Scripps News. Thank you, as always, for taking the time to speak with us about this.
Right.
One question following up on an earlier question about this announcement, and then another on News of Day, if I can. Just given the Trump administration's, public disapproval of or lack of interest in disparate impact investigations. I'm wondering if you've been in touch at all with federal counterparts about this investigation and if you're at all concerned about the administration trying to stymie this investigation in any way. And then on News of the Day, as I'm sure you know, just a few minutes ago, the president and EPA administrator announced the rollback of the endangerment finding that undergirds most regulations of greenhouse gases. I know the state had submitted comments to the proposed rule, just wondering now that this has taken effect, your reaction, and if the state might pursue a legal challenge to this move. Thanks.
Sure. So let me answer the first question first about the federal government's position on disparate impact discrimination and whether we are concerned that they might interfere with our investigation. This is a state investigation brought by a state law enforcement agency on issues within our state. It's fully within our jurisdiction, very clearly in an area that we've worked on for years, which is civil rights enforcement. This is what we do. We've done it time and time again in different environments, applied to different places and spaces, and it's fully appropriate for us to do this here under these circumstances. I don't know what the federal government will do. They have done things. They do shocking things that are not surprising. That's kind of their brand. They do unlawful things, like the 57 unlawful things that they've done and that we've brought lawsuits on in just over the last year. So might they try to interfere here? Wouldn't put it past them, but don't know. Not their lane. Wouldn't be appropriate. They have no right to interfere. This is our space. This is our lane. This is what we do. We're moving under state laws on a theory completely available under state law as as the top cop, the chief law enforcement officer for this state on an issue within our state, period, full stop. So, but again, don't know what they'll do, up to them, but they have no right to interfere here. With respect to the endangerment finding, that is also on brand for this federal administration, unfortunately, to be anti-facts, anti-science, anti-health, anti-future of our planet, anti-appropriate climate action, given the facts right in front of your face. It is a put your head in the sand, give away to the fossil fuel industry while vulnerable communities suffer, while health suffers, and while the environment suffers. And so, this is not unexpected. This is what they do. While the federal administration attempts to undo environmental protections that are very clearly backed by science, California is going to do what we do. We will be a bright light and a fact-based, aggressive actor when it comes to tackling climate change. It is a issue that requires a response that is equivalent in scope, scale, and speed to meet the moment. And California, respectfully, has led this nation in the world and will continue, despite what this federal government it does, that is backwards and anti-fact and anti-science. And actually, we will lean in more heavily, given the absence of appropriate leadership at the federal level. So we will challenge illegal actions in court, continue fighting to defend public health, uphold environmental justice, and protect our future generations. And we are always prepared to take action and not shy to take action when California is hurt and the law and the facts determine that an illegal action was taken by the federal government. We will hold the federal government accountable in those circumstances. And we have nothing to announce today, but we are eager to act as appropriate here as well.
Thank you. Next question comes from Macy. You are now unmuted.
Hi, Attorney General Macy Jenkins with NBC4 News. Just to follow up, I'm not sure you gave us specifics or as specific as you can give an answer on the possible outcomes, whether it's criminal or
Right.
civil accountability. If you can speak on that, that would be great. And then my other question is, what is your recommendation to Altadena residents, for instance, the ones with Altadena for Accountability who have been saying for months, hey, we need some kind of investigation. What's your recommendation for those people who want to contribute to the investigation? Will you be holding any public meetings, or will there be a hotline for them to reach out to you to say, hey, I want to tell you my story, or come investigate this piece?
So first off, let me answer the second question first, then I'll answer the first question second. But thank you for repeating that question. I did miss that before. It was unintentional, and I apologize, and I'll answer it here. Altadenans for Accountability. That's what I was talking about when I was sharing that. I'm grateful to surviving families and loved ones who have come forward, who've raised their voices, who, in the middle of pain, have found the courage and the strength and the resilience to speak up and speak out, share their stories, as painful as they are, and seek answers to their questions. They deserve answers to their questions. And so I've been in touch with them. I've met with them. I've met with them in person. I've heard their stories. They're painful. They're powerful. They're compelling. And that is in large part why we are here today. Because, as I mentioned before, hearing stories from individuals who have been hurt, who are suffering, and knowing that I can do something about it, given my role, has always been the most powerful call to action for me. That's just the way I think and the way I operate and the way my heart works and my values work. So what do I say to them? We're investigating, and we're going to do everything in our power to get the answers that you deserve, that you've been waiting for too long, and we will get the answers. We will look. We will look diligently and thoroughly and comprehensively, and provide answers. Our focus here to the issue of sort of remedies or what actions we might take. This is a civil investigation at this time. We were looking into civil rights, potential civil rights violations that essentially could have happened if there are any, and we haven't predetermined that, that happened at a sort of systems and structures level. Where our main focus is to make sure that that what happened here won't ever happen again. And we are looking through the lens of a civil rights investigation into systems and structures that contributed to a delay in LA County's evacuation notice and possible other disparities in emergency response in West Altadena. So I don't want to get ahead of ourselves on potential remedies, but I do want to emphasize this is a civil investigation. We are looking at systems and structures, and besides that, we'll need to get into the investigation a little further, look at the facts to see where we might end up.
Thank you.
Next question comes from Dave. You are now unmuted.
Okay. Yes, good morning, Attorney General Bonta. This is Dave Mason with the Center Square. We all certainly appreciate your time. I'd like to ask you today about the ban on masks on federal officers, including ICE officers, that took effect in January. The Los Angeles police chief has said he will not enforce it because he doesn't feel it's doable to have one law enforcement agency enforces another one. I know this has gone through the courts. So my question is, where is this in the courts? And is this ban enforceable? Is it going to be enforceable strictly by state DOJ, or will local law enforcement help with this?
Let me answer the second question first about who's going to enforce a mask ban. Should there be a mask ban in place in California? The answer is all law enforcement agencies would be involved in that potentially. They would have the authority. And like any law, would use their judgment based on what they see, and with respect to any violation of the law, and and enforced as appropriate. I expect, should this become the law of the state of California, like any law, it be treated the same, that it be enforced as appropriate. Laws are there to be followed, laws are there to be enforced if they're not followed. So that's the answer to your second question. To the first question, it is not currently the law of the state of California. A preliminary injunction was granted by a judge earlier this week based on a federal challenge that the federal government brought on the masking component. There were two laws before the court, both sorry to get technical on this, but both were being challenged by the federal government through what we call a preliminary injunction motion, an attempt at an early stage in the case to block the implementation of the law. And the court found that as to the masking law, the preliminary injunction was granted, and the court laid out a whole set of rationale and basically cleared a pathway for there to be, in my opinion, my read of the court case, a pathway for there to be an actual enforceable anti-masking law that applies to federal agents, but the current law didn't follow that pathway. There was a second part I just want to note that was the preliminary injunction was denied and is the law of the state of California. It's the identification law that requires federal agents to have some sort of notice of who they are, their name, a badge number, their agency or department. That was completely upheld. That is the law of the state of California today. Based on this preliminary injunction, I do want to flag that a preliminary injunction, as I mentioned, is an early action in a case. The case continues. There could be a summary judgment, there could be a trial where additional decisions are made by the court that determine what laws are in place or not in place. But for now, because the preliminary injunction was granted as to the masking law, the masking law is not currently in place in California. Should there be a law in the future that requires anti-masking of federal agents and is upheld by a court, I would expect law enforcement agencies to treat it like any other law. And I would expect federal agents to follow it. And I would expect law enforcement agencies, including mine, to participate, just like with any other law, in appropriate enforcement.
And a follow-up question. Since the tragic fatal shootings in Minnesota, have you noticed any more restraint on the part of ICE officers in California, or have there still been a lot of incidents?
Well, the killings, maybe murders, but depending on what the investigations show, of Renee Good and Alex Pretty, were disgusting, sickening, tragic, and never should have happened. They should both be alive today. So I'll say that. The ICE agents involved in Minnesota in Metro Surge that led to those killings, they were reckless. They appeared untrained. They escalated instead of de-escalated. They were unnecessarily violent, and it led to the killing of two United States citizens. Again, that never should have happened. There was talk, and I believe there was acting behind that talk to following those unnecessary, tragic, disgusting, and sickening killings to scale back and scale down and de-escalate in Minnesota. Some of the major problems of ICE in America at this time continue. They're masked, they're armed, they use unnecessary force, they are traumatizing and terrorizing our communities, they are racially profiling our communities. They are using warrants that are issued by their own agency, not an independent judge, and they think that's appropriate. So there is a lot of the things where they're roving, and they're, they don't have a good consistent use of body cameras. And there's a lot of these reforms are on the table now in Congress. And I think that congressional Democrats should hold firm and hold strong and ensure that there's accountability and reform and change in ICE as currently constituted and the way it's practicing. It's hurting our communities. It is hurting and undermining public safety. People are dying, and it needs to change. So let me just say that. In California, a lot of these practices that I've just described have carried over into California. Thankfully, at least now, up to now, not at the same scale and level of severity that we saw in Minnesota, but we don't think that that might not happen. We think it might very well happen. And so we're prepared. And thus, our portal that I talked about earlier in response to another question. Californians, tell us what you see. Tell us what you're experiencing. Tell us what you're witnessing. We want to know. We want to get engaged if appropriate, if there is misconduct and illegality, unlawful actions. So, thankfully at this time we've been spared the level of severity of the harm visited by ICE that Minnesota experienced and should never have had to. But we think it could easily escalate here in California. California has always been a target of Trump. It will continue to be. It's for pure, outrageously political reasons, because we're the biggest blue state that has never voted for him. That's it. That's how he thinks. And for that reason, he put National Guard on the ground in Los Angeles. He's threatened California multiple times. That's why we've had to sue him 57 times and protect $188 billion of funding and get the National Guard that was improperly federalized out of our streets, and many other actions that we've taken. But the patterns and practices of ICE that are so unacceptable, we have seen them in California. They continue to be unacceptable. We'll continue to be vigilant in our response.
And my last question related to the fire, how long will this investigation take? And will this investigation possibly result in financial compensation for the victims in Altadena?
As to the first question, we never want to predict how long it will take. I hate to say it, but it depends. Our hope is that we have full cooperation from every agency and entity and individual that we reach out to for information. And I have no reason to think we won't. And if we have that cooperation and we get the information that we seek, the investigation will be faster. We'll get the answers faster. And but we're talking about multiple months. We're not going to have a conclusion next week or even next month. It takes time to do it right, to look hard, to look thoroughly, comprehensively, accurately. So besides that, I can't give you any more specific answer, not because I don't want to, I just don't know. But that is my best estimate, that it'll take multiple months. At the end of the investigation, and I don't want to jump there because we're at the beginning without saying the facts will matter. We haven't prejudged them. We don't know what we'll find. And generally, in an investigation like this, the remedy or the outcome would be along the lines of different practices, different policies, different training, sort of systems level change, not money damages for a specific individual. There's another way to pursue that, should that be appropriate. And this case, a case like this, investigation looking into practices and systems is not generally the way that individuals would receive monetary compensation.
Great. Thank you very much.
Thank you. Next
Thank you.
question comes from Esther. You are now unmuted.
Thank you, Attorney General Bonta, for spending some time to talk with us. This is Esther Wickham here, education reporter for the Center Square. I had a question regarding your recent lawsuit against the Department of Education over the California Department of Education's alleged violation of FERPA. I was wondering, within the lawsuit, what is the primary objective and how could that potential termination of almost $5 billion, impact the state due to the alleged non-compliance? And then if also you could talk a little bit about the U.S. Department of Education's, raising the concern about parental rights. Do we see California citizens raising that concern as well? How do we find that balance between, respecting parental rights, but also valuing student safety? And, how can your office, as well as the California Department of Education, demonstrate that they're meeting legal requirements and regulatory requirements to avoid, losing those funds?
Thank you for your question. We brought a lawsuit yesterday against the U.S. Department of Education regarding its allegations that the California Department of Education has facilitated policies and practices that violate, as you mentioned, FERPA, the Family Educational Rights and Privacy Act. Let me be clear. The California Department of Education fully complies with FERPA as it's written. And the attempt to withhold $5 billion in state education funding. Let me be clear, this is funding for children, for public schools, for parents. It's wrong. And there's a lot at stake. It's $5 billion in education funding for those who need it. And so we brought a lawsuit here in the Northern District of California, and we are already winning. We secured a temporary restraining order yesterday, blocking the attempt by the U.S. Department of Education to unlawfully withhold the nearly $5 billion. So the Trump administration has been fond of looking at a law that is clear on what it requires and then twisting it and changing it, rewriting it in their own minds into something that it's not, that is consistent with their own political agenda. And they've done that here. Again, California Department of Education is fully compliant with FERPA as written. The twisted, perverse, absurd, inappropriate rendering of FERPA by the U.S. Department of Education doesn't exist in the law. The Trump administration is in the executive branch. They are not lawmakers. Congress writes laws, and Congress hasn't amended FERPA. So we are, and the Trump administration has done this multiple times. They've tried to suggest that diversity, equity, and inclusion programs, so-called DEI programs that tackle harassment and tackle discrimination, are somehow discriminatory. To them, black is white, up is down. They twist and they turn and they, absurdly change laws into some figment of their imagination that doesn't exist. And they've done that here again. So our North Star here is the law. That's it. What does the Family Educational Rights and Privacy Act require? We will follow every part of it and fully comply with it, and we have. But the Trump administration can't change the law with their own absurd rendering of it in their own mind, and then say you're not following. You might be following the actual law that FERPA stands for, but you're not following our absurd version of it, and so we're going to withhold $5 billion from you. Can't do it, and it's not going to happen. They've done this before. We've won before. If they want to do it again, we can go through this process. It's unfortunate that we're fighting the federal government, who is acting so lawlessly, to retain funds that Congress has already appropriated to us and that we deserve, and there's no basis for withholding. But if that's what we need to do, we'll do it. And on your question around, what an appropriate policy should be with respect to parents' rights and the privacy, the safety of children, that is a policy issue that policymakers can appropriately discuss. That's not what this is. This is about what the law is as currently constituted and set forth very clearly in black and white in FERPA. And we are completely complying with it. And there's no basis for the $5 billion, nearly $5 billion to be withheld. And don't take my word for it. Ask the court, who just issued a temporary restraining order within hours of our filing yesterday.
Thank you.
Thank you. About two more questions. Next question comes from Grace. You're now unmuted. Sorry.
Sorry. Hi, Grace Tui again with the LA Times. You mentioned the Los Angeles County Fire Department in your announcement about this case. I wanted to better understand, one, if they're aware of this investigation, if they've been cooperative so far, and then I guess will the scope of the investigation include other county agencies as well, the Sheriff's Department, the Office of Emergency Management, to name some who I know were involved in evacuation alerts. And if you can talk about the scope a little bit. Thank you.
Yeah, sure. Broadly speaking, the investigation is just starting. Obviously, one of the major, the primary responding agency was LA County Fire Department. So we expect to be seeking information about, their response, and we expect cooperation. No reason to expect otherwise, but we're just getting started. So, there's nothing to retroactively tell you about because we're just getting started. And so it's prospective, and we expect cooperation, and no reason to think we won't. Of course, there was mutual aid involved in the response in Altadena, and to the extent there was other entities that were involved in the key questions that we're asking that led to the key questions that we're asking about what led to this disparate impact that we saw, the delay in the notice for evacuation, for example, in West Altadena. That would be an appropriate part of our scope as well. But I can't tell you every entity that falls within that purview. But we're well aware that there may be others, and we will seek information and facts from all appropriate entities that can help us answer the questions that we're asking here.
Thank you. Last question comes from Maya.
Hi, me again from Bloomberg Law. I also wanted to ask, we've heard from wildfire survivors how important it is to get answers about what happened last January. Can you speak about the extent to which the results of the investigation will be made public and, where, how, all that?
Yeah, and as you actually asked that question, I realized there was a prior question about community involvement and engagement. We expect to be involved with the community and engage in different ways, potentially with even some public types of engagement. TBD and more to come on that, but community engagement is very important. Voices of community members, specifically surviving families and loved ones, were a major part of surfacing the issues that raised concerns with my office and led to this investigation. So we will continue to have that type of engagement. And tell me your question again.
No problem. Just, the extent to which the results of this investigation will be made public. Yes.
Yes. So these investigations are the way they have to work, but it's not always ideal from my perspective, but it's necessary. Sometimes we make an announcement like we're making today, and then we go do the investigation, and it takes time. It's important that we be careful and comprehensive and accurate and thorough in our investigation. And folks are wondering what's happening. They're not sure how far along we're getting, what we're finding, and we can't and typically don't share that information. And then at some point when the investigation is concluded, months down the road, generally, we will make a public announcement. We will announce the results of the investigation. So there will be a public announcement of the results of this investigation. When that will be, don't know. What those results will be, no idea. That's why we're doing the investigation. But there will be a public component at some point. Maybe even a written report, don't know that yet, but certainly a report out in some form about what we found. That's an important part of this process of accountability, of transparency, of building trust, not just to say that we've launched the investigation, but to, at the conclusion of the investigation, share what the investigation found, and we will do that.
Thanks.
Thank you.
And that was the last question.
Super. Thanks for joining, folks. Appreciate your time, your patience.